services in mediation, arbitration, negotiation, and comprehensive dispute management independently. Today, we, together with Uganda Registration Services Bureau, curated this conversation around the realities that we see here in our companies and corporate sector. Aside from my work with the Dispute Settlement Hub, I also serve as the acting head of the Corporate and Commercial Department of ALP Advocates, where I spend a good time of my work advising clients. So today's conversation is my everyday experience. To bring a comprehensive view to our discussion today, we have two speakers from two sides of the table, which is a private practitioner and also a representative of the regulator. First, we have Mr. Daniel Nasasira, who is joining us from Uganda Registration Services Bureau. Daniel is an advocate of the High Court of Uganda, and he's a chartered governance professional. He's an associate member of the Chartered Governance Institute of the UK and Ireland, and has also obtained additional training from the Oxford Site Business School. He also has obtained additional training from the World Intellectual Property Organization and currently serves with the Uganda Registration Services Bureau, where he has delivered a number of rulings. I believe most of us here must have interacted with his work. So from the regulator side, he handles the disputes personally and hands-on. Secondly, we have Mr. Laston Gulume Baliaino, who I'm also fortunate to work alongside with at ALP. He heads our dispute resolution practice group and is also a notary public. He handles disputes right from the outset and also brings in the advocate's perspective, which is the preparation of documents and the setting up an establishment of companies. And so he brings the perspective of a practitioner who handles shareholders, who supports with the preparation of the shareholders agreements and the documents which eventually end up before Daniel at the point of dispute. So together, they will give us both the regulator's lens and the advocate's lens on the same set of problems, which is the conversation that we would like to have today. So let's get right into it. We'll start with a brief introduction, an overview from Laston. Laston, please confirm that you can unmute your microphone. Laston, I can't hear you. I don't know if it's just me.
It's not on. We are not hearing him.
Okay. Laston, there's a problem with your audio. Apologies for that brief disruption. We'll resolve it and continue with the presentation shortly. Yes, we can hear you.
I studied with that recent technology and just actually, of course, allow me I was saying that this partly was thinking that the light is in the spot of the person and people, the place and the industry and and I say that in today's world, there is always no other ways of doing business effectively. Which is at one point is not
Laston, your microphone is not clear. You might have to. You're not really audible. The sound is not clear.
Change this thing a bit. Just give me the Bluetooth speaker.
Yes.
Yeah. Okay, is that much clearer? I've just had to call into the aid of another
It's
device.
perfect. Now we can hear you.
Okay, I think my computer kept connecting to a Bluetooth speaker, which I was not with here. That is why you were not hearing me well. But thankfully, it's part of resolving disputes. That's how shareholders have to deal with disputes. One of the causes of shareholder disputes is communication. So the sooner the communication line is dealt with, the sooner shareholders are able to do business together and to do business effectively. But apologies for that glitch. Diving into the conversation, managing shareholder disputes through alternative dispute resolution, we want to first put a bit of context to what is a shareholder dispute. Not every dispute that arises in a company is a shareholder dispute. Not every dispute really that arises in a business is a shareholder dispute. As Daniel will later even guide us better, there are disputes that will go either before the Register of Companies, disputes that will go before other forums of alternative dispute resolution, disputes that will sometimes end up in court. And at the bedrock of this dispute is these people who came to do business together are not seeing eye to eye. And in companies, mostly business companies, we are referring to shareholders. And it's either a dispute between shareholders specifically, it could be a dispute between the business owners and the company itself, or a dispute between the business owners and the directors over either ownership, issues of management, issues of control, issues of the affairs of the company. So this kind of conflict that we are calling a shareholder dispute and how you manage them will usually come from how are the affairs of the business being run and how are the rights, expectations, interests of the shareholders being protected or being prejudiced. And this kind of dispute can be legal in as far as maybe the governing documents are concerned, interpretation of the governing documents, enforcement of the governing documents, or the dispute can be a commercial disagreement over who should be having what shares, to what extent can these shares be diluted, to what extent can the interests of a particular shareholder be diluted, and to what extent, in as far as the shareholders could have agreed when they were setting out to do business together, rights can be compromised, and so on and so forth. What we want to further put context to before we discuss how you manage these disputes is that, unfortunately, if it were a mere dispute of, an employee with the employer as a company, it may not have the bigger disruption to governance like a shareholder dispute does. A shareholder dispute can have a very, very huge disruption to the governance of the business and the company. It can damage investor confidence. The more you interact, like Lucy was saying, that this is what she does as a bread and butter, but the more you interact with advising businesses how to onboard, mostly if you're dealing with private companies, how to onboard investors, raise capital, you are likely to find out that there is a lot of due diligence that is done on a company before an investor can invest in it. So a shareholder dispute can have that effect of even impeding business operations where you have deadlocks, standstills of the business, and can significantly reduce the value of the company. The value of the company may not be limited per se to the assets that the company has, but also whether the company's status, the company's going concern, is seen in any liabilities that the company may have in outstanding disputes. For some people that have advised companies or written legal audit letters when auditors are auditing, the auditors will ask, are there any outstanding cases, litigation, any outstanding disputes, any outstanding liabilities that are arising from disputes involving the company, and usually by extension, of course, involving the shareholders and directors and so forth. So if you're to think about what we are calling a shareholder dispute, you can simply think about scenarios where you will have shareholders not agreeing. For example, if you have two equal shareholders, they have 50-50%, hold equal shares in the company, and they fail to agree maybe on something like whether they want to sell the business or not sell the business. And that alone can lead to a management deadlock. Management can't proceed with the decision, but also it remains in the pipeline, and that can lead to a dispute. A majority shareholder, for example, can want to issue additional shares exclusively to themselves, thereby diluting the minority shareholders' interests. What does that mean? There are scenarios where you're dealing with resolutions that should be passed by a certain percentage of shareholders that hold a particular percentage. Now, if you have a controlling majority shareholder, a high control, I see Ahimbisiwe is unmuted, where you have a controlling majority shareholder passing a resolution or a decision in a meeting where maybe all shareholders are attending, and even if you don't agree with the decision, of course, the company's documents, the company's articles would give them that power to do so. And that can lead to a dispute because the decision would have an effect of diluting the minority shareholders' interests. Take an example of directors refusing to provide annual financial statements despite being asked to do so. Now, when you come to public companies, the corporate governance structures there by virtue of regulation are much more stringent and rigorous. So when it comes to private companies, thankfully we have Daniel on call. He is likely to share with you that what you see, the ideal, what you see on paper is not what you find in these maybe family founded businesses, private businesses. So what seems to be simple and straightforward can be a place where a dispute can arise. A founding shareholder, for example, may secretly transfer company assets to another company they own. We have handled some companies where you have one individual and their name is across almost 20, 30 companies. They are founders in all those companies. Some of them are family companies. Some of them are joint ventures founded with other investors. And the mere fact that this person is a founder across all these companies, when you mix the assets and the businesses of one company into another, you end up having shareholder disputes and disagreements. Take an example again of a shareholder who is excluded from board meetings, and maybe they are denied access to company records, even when it's expressly contrary to the company's governing documents. So the point is, the source of shareholder disputes and their causes will arise from the relationship between or among shareholders in the same company. However, the conversation today is to help us understand, how do you manage them? Probably, how do you even prepare, or how do you even avoid them? In Uganda specifically, shareholder disputes are not merely disagreements over profit. There are not many companies making huge profits that the shareholders are going to be disputing over the dividends per se. But you see the trends seem to show that these disputes arise from either breakdown of trust in the governance of the company, matters of oppression of minority shareholders, breach of fiduciary duties, disputes over ownership of shares, who should have what shares, where maybe there are things of increase of share capital, and they tell the company secretary, you allot these shares, and they just go ahead to allot the shares pro rata. Resolutions are signed and they are filed with the URSB, and behold, these people before Daniel saying, no, these additional shares were supposed to be allocated differently and not the way they were allocated, but yet there are resolutions that have been signed. They could arise from exclusion from management of the company, or even misuse of the majority control of the company. Now, if you have well-drafted governing documents such as articles of association, and this is where people like us and some of the people I'm seeing on call here come in, as corporate advisors, as company secretaries, as business advisors, as investment advisors, if you have well-drafted governing documents, you have well-drafted shareholders agreements, you have transparency in the governance, and when the dispute arises, you call to your aid the timely use of alternative dispute resolution mechanisms. You are likely to manage what would have escalated into a very protracted dispute in a more effective way. So you find that certain alternative means of dispute resolution, like mediation, like conciliation, negotiation, or expert determination and arbitration. Expert determination here, if it's really just an issue of knowing what is the valuation of the shares in the company. There was a scenario we were handling where the company wanted to do a buyout. The company wanted to do a buyout. There are issues of restrictions against reduction of capital, but we can't even take that step without first getting a determination as to the valuation of the shares that the company will be required to buy back. Interestingly, it would shock you that not many people want to get involved in such circumstances where they smell a rat of a possible dispute. But in this webinar, some of the things we are going to encounter are things such as, how does a company work with professionals across to be able to manage its affairs and also be able to manage some of those disputes. So main causes, where do these disputes arise from? You have a shareholders agreement, which is one of the most key documents that is used in defining the rights, responsibilities, obligations, and rights of shareholders. So if you violate that agreement, definitely there will be a dispute, and usually those disputes can be very, very protracted and even very complex. You fail to honor preemptive rights, selling shares without obtaining the required consent or the procedure agreed to, breach of non-compete obligations, failure to contribute the agreed capital, among many others. And as far as the shareholder agreement requires it and you don't comply, if you breach it, then it can be a source, it can be a cause of a shareholder dispute. Mismanagement of the company, generally, you misuse company assets, engage in self-dealing, make decisions that are contrary to the company's assets. And some of the things that end up, Daniel, it's usually difficult to look at these business owners going at each other, and you would think that if they deployed maybe an alternative, approach to this before escalating it to litigation and so on and so forth, it would help to make better decisions for the company. But it's even made worse when there is no proper keeping of accounts or proper books that are kept. So when you're dealing with issues of accountability, you want forensic audit, you find that there is even no information that the company can rely on or shareholders can rely on to align their misunderstandings or understanding of how the company has managed. Minority shareholder operations, these are really very common in some of the cases that are out there, where a minority shareholder is saying, I'm not participating in the management of the company, and they need to be helped to understand to what extent do you participate when you're looking at the annual general meeting as an organ, you're looking at the board of directors as an organ, then maybe you're looking at the executive team that is usually led either by a managing director, and the shareholder is saying, I need to see myself participate in the management of the company, and probably they are misunderstanding or they don't comprehend properly at what level do they participate. Withholding dividends, the company can declare dividends for the year, and then a decision is made that, you know what, we will not be distributing these dividends, and how those decisions are made and how they affect shareholders can sometimes be a source or a cause of a dispute. Denying access to company information, issuing new shares intended to solely to dilute minority interests, and an unfair removal of maybe a director. Usually you'll find in private companies that you can find a shareholder also doubling as a director. So when they are removed, you can have a mix-up of, are you dealing with an office of a director? Are you dealing with rights and roles of shareholders? Deadlocks. A deadlock is when you have an impasse in making the decision. And this is where you have probably equal rights, 50-50 shareholders. Inability to appoint directors, 50% of the shareholders say we want this director, the others are saying we don't want them. Disagreement over strategy. What does a company will have objectives, and the assumption is that the business of the company is led by those objectives. But objectives of the company probably grow. The strategy of the company to implement those objectives is likely to change over time depending on the business environment. So when you have a disagreement over strategy, these shareholders, 50% are saying we should adopt this strategy, the others are saying it should be a different one, and you'll have a deadlock, no decision being made to move forward. Disagreement over financing. Should we go for debt financing? Should we do equity financing? How do we raise capital for the company? Disagreement over sale of a business, and so on and so forth. The point is that the paralysis in the inability to have a decision made and implemented can really be a very big source of shareholder disagreements. Dividend disputes, I will not belabor that. Share valuation disputes, some say no, the value of the shares of the company, when you do a valuation, the shares have gained value to this extent. And some of them are based on assumptions that could not be accurate. And that is where the valuers come in, the professionals come in. When one shareholder leaves the company, when there is a compulsory buyout, when shares must be valued following probably death or insolvency, and there is no clear pathway on how you come to valuation of the shares in the company to enable decisions being made. Removal or appointment of directors can also be a source of shareholder disputes. Transfer of shares. Daniel, I believe, has handled quite a number of disputes around this, where sometimes you have complaints that the share transfers were forged, you have competing claims over ownership, you have people who say, I have shares in the company, I am not on the register, where you have now courts going down the road of looking at who has been declared as a shareholder in the annual returns. The Rochikaire decision, where a court now looks at other indicators to know who is a shareholder and who is not a shareholder in the company. Of course, if directors breach fiduciary duties and some shareholders are backing the actions of the directors and others are opposing the actions of the directors, that can lead to shareholder disputes. These days, there's a lot of fraud and financial impropriety, even in private companies. This is a real threat. And because when it happens, sometimes in private companies, you have the shareholder is a director, then the fraud is happening at their watch, and now it's not clear how do you treat this issue. Do you go after them as a director, but also in the meetings where shareholders are sitting and receiving reports and discussing the implication on the business, they are also sitting there. So the fraud, financial impropriety, where you have falsified accounts, issue of undisputed party transactions, they can. Yes, saying that for people who are advising shareholders, people who are advising companies, what you want to look out for is ask yourself some of these few questions as a checklist. Do we have a written shareholders agreement? Arguably, a shareholders agreement is one of those documents that is used globally in trying to put detail to this relationship among shareholders. Are our articles of association up to date? In our draftings, we sometimes use precedent, and URSB made our work very easy by introducing what we call the lean memos. You just adopt, table A. If you have any amendments or any changes to table A in as far as articles of association are concerned, you should be able to indicate those changes that you want to add there. So ask yourself, are our articles of association up to date? And for purposes of today's conversation, you likely want to be looking at the dispute resolution and dispute avoidance clause. Do we hold regular board and shareholder meetings? If meetings are not happening, shareholders are not communicating. Are financial statements shared with shareholders? Your name can be on a company and people presume you're making a lot of money by the profit you're receiving, yet the company, while it's still a going concern, it's not making profit as people may assume it is. Do we have clear dividend and profit distribution policies? When the money has not yet come and you have a clear way how the money will be distributed when it comes, it helps you to avoid disputes or at least manage them in a better way. Is there a succession plan? In companies, a company outlives its members. And because a company outlives its members, a succession plan for directors is important. A succession plan, of course, we have provisions in the articles of association, such as transmission of shares. You want to look at those and make sure that they are very clear. Is there an agreed dispute resolution mechanism, or we have left ourselves to fate? Are directors trained on their fiduciary duties, or we just appoint people and tell them run with the company when they don't know what their fiduciary duties are? Are conflicts of interest disclosed and managed? Do we have a conflict of interest check? Do we have a means of, confirming that there is no conflict of interest? And if there is any conflict of interest, is it disclosed? Do we know the procedures of disclosing these conflicts of interest? Is there a clear exit strategy for shareholders? If a shareholder wants to leave, or if you want, there is necessity as reason that this shareholder probably moves on from the company, do you have a clear exit strategy for shareholders? In avoiding disputes, there are things that you want to, they may not even be legal per se, but if you think about them, if you advise clients about them, if you're in-house counsel, there are things you just want to always ensure. Financial transparency, separate personal affairs from company affairs, respect minority shareholder rights, establish a clear dividend policy, provide for these exit mechanisms, include share transfer restrictions in your shareholder agreements, clearly define directors' duties, manage conflicts of interest, hold those regular meetings, develop that succession plan, and have that culture of trust and communication. The shareholders should know that if the communication comes from the source, it should be trustworthy communication. There is a way shareholders can want to do due diligence on each other. This shareholder asks the company secretary about this, the other shareholder asks this director. You have informal meetings, sitting, and there are all sometimes these internal dealings that compromise the levels of trust. Now, at the center of the shareholder relationship, as I come to my end of my presentation, is this thing called the shareholder agreement. Have it as comprehensive but also tailor-made to your expectations as a shareholder. If you're an advisor, there is the temptation of getting a template, what you did for another company, and you want to just put it out there, and these people sign it and they move on. You may want to have a comprehensive conversation with the shareholders on what they expect, on the ideal relationship that they want to have as you advise them. Because unlike the articles of association, the shareholder agreement will regulate those private, matters, those private issues, those private aspects of the shareholder relationship, and address them in a way that may not be suitable to be put in the company's articles of association per se. So many disputes simply arise because shareholders had certain assumptions. I assume this person will bring in the money. I assume this person will do the executive directorship of the company. I assume this person will carry the legwork of looking for the business of the company. And because of those expectations that were never reduced into writing, you end up with disputes. Some disputes are legally difficult to even resolve in the courts of law. And that's where the alternative dispute resolution mechanisms become a very, very, very good aspect and procedure to think about. At the center of our conversation today is not to discuss what a shareholders agreement should be, but mostly the dispute resolution procedures that a shareholders agreement should think about and should be able to adopt. In addition to the shareholders agreement, of course, clear articles of association are very ideal. Outside Uganda, some countries refer to these as the constitution of the company. But the articles should be very clear. And like I said, probably as you're adopting the lean memats and you're adopting table A, if there are certain modifications that you want to adopt, please ensure that they are adopted and they are indicated. Sometimes the ambiguous, governing documents create the unnecessary litigation where quorums are not clear, they are neither here nor there, and people are not very sure. Define roles very clearly. When a person is holding the heart of a shareholder, the director, they are also an employee, they are now lending the company, then they are guaranteeing the company when the company is taking on, borrowings. You need to define roles clearly, and each role will carry different rights and obligations. So if you have a shareholder who is also wearing another hat and they want to exercise their rights in respect to that particular role they are playing, it should be clear that if it's not a shareholder kind of role or right, then it should not be mixed up. Otherwise, you end up with disputes that are not, and they end up dragging the company into protracted disputes. Maintain proper corporate governance. That is not really something we can be able to resolve or comprehensive discuss today, but have proper corporate governance structures. When you anticipate a deadlock, prepare and have clear deadlock resolution procedures. That is also something that is quite comprehensive, but it's one that you can capture in the shareholder agreements, capture in your articles, capture in your governing documents. What happens when surely you want someone to be gone from the company, but they also have rights, and you have to find a way of buying them out and having those conversations. This one, using independent professionals, I personally have seen it that a number of companies don't think that you maybe need lawyers unless you're in trouble. You don't need auditors until you have URA tax audit issues or URSBs insisting that we need to see your audited accounts. You know, having a company secretary who is an actual professional, you saw, or your brother, you have had Daniel's profile as it was being read by Lucy. There are people who have dedicated time to study, to build competence in being actual company secretaries. But because maybe companies cannot afford the budget of a company secretary, they'll just nominate any one of, either the shareholders or the directors to double as a company secretary until trouble falls. Have engagement of valuation experts. When you're transferring shares today, you're going to be required to have at least that share valuation form filled and signed off. Sometimes when you're telling clients that we need to have a valuation of the shares, they'll tell you, no, don't waste our time. That is another expensive process we are going through. Until you have a shareholder dispute and the nominal book value of the share is not what represents the value of the company. So independent advice reduce suspicion, and they help improve on compliance aspects. They help improve on compliance aspects. How do you avoid the shareholder disputes? And by having a very robust dispute escalation clause. This is a long conversation, but let me summarize it in 3 things. 1, choose the different means of dispute resolution you may want to adopt in your dispute resolution and dispute avoidance clause. So when you choose those, explain to the shareholders what they mean and what they involve. Sometimes shareholders sign off on these shareholder agreements, but truthfully, they have no idea what it takes to resolve the dispute through those processes. In my view, an ideal dispute avoidance and dispute resolution clause should really establish a clear pathway from day one when the dispute arises to when we expect the dispute to be resolved. Have clear timelines. Have an escalation pathway that if the dispute has begun on this day, these are the processes we are going to go through to resolve it. These are the processes we are going to take to resolve it. That dispute resolution escalation clause, as I finish, at least should give you those different forums where we can maybe negotiate through the issue, engage maybe a mediator or an expert, depending on the nature of the dispute. And then after a certain period, we can commence arbitration. And then you should be clear, how are you going to go through the arbitration appointment? Is the arbitration clause clear? Does it give you the law of the arbitration? Does it give you the forum? Does it give you how the arbitration is going to be handled and where it's going to be handled? Finally, cross-border disputes, things like the jurisdiction and applicable law, which we overlook when we are drafting our documents until you don't know, are we applying the law of Uganda? Are we applying the law of England? Are we applying Kenya law? What law are we applying? And when you have figured out and clearly indicated the law that is going to be applied, it will make the recognition and enforcement of decisions easier. Now, ADR seems to be favored when it comes to the dispute resolution and enforcement, because when it comes specifically to arbitration, you have this international framework of recognizing arbitral awards, and they can be enforced in the respective jurisdictions when it comes to cross-border enforcement. We also want to watch out for the culture and regulatory and governance differences, mostly when you're having companies that have shareholders from different jurisdictions, different cultures, and how they approach governance issues. To mitigate the risks that come with this, the company should, of course, adopt harmonized documents. They should adopt clear communication channels. And because the shareholder disputes are between people who are doing business together and they are investing, putting money into the business together, they may not be per se your disputes that are between two likely strangers who we have done business as a one-off. For lawyers that are handling shareholder disputes, sometimes you'll have the unfortunate privilege of sitting in meetings and people who are business partners are going at each other, accusing each other, but yet the company has not been dissolved. It is still continuing, and the appeal task will be, how do you manage that dispute effectively for the company to remain, the business to continue, but also not to hide your head in the sand like an ostrich, like the dispute does not exist. Lucy, that is the quick run as much as possible that I could do within the limited time. But since I know also Daniel has the bigger and more better perspective from a regulator's perspective, you'll allow me end there, and then we can pick it up with Daniel from there. Thank you. Thank you.
Thank you for your in-depth presentation. I like where you've ended it at. When the dispute has arisen, the objective is to keep the company going, to ensure that it does not die with the death in the relationship between the shareholders. So now for our next presentation, we'll have Daniel Nasasira from Uganda Registration Services Bureau, who will take us through the regulator's perspective and also the various modes of alternative dispute resolution that are currently available through the registry. Daniel, you're welcome.
Thank you, Lucy. Good evening, ladies and gentlemen. Hopefully you can hear me.
Yes, we can hear you.
Okay, that's great. Thank you, Laston, for that very elaborate presentation. Much of what I intended to say has really been said by Laston. So my name is Daniel Nasasira, as has been introduced by Lucy. And my role here today is basically to take you through the role of the Register of Companies in managing shareholder disputes. So most people spend a lot of time planning how to start a business, and they don't pay particular attention in planning the relationship and what could happen in case the relationship gets sour. So it's important that we spend more time planning the relationship than really entirely spending all that time planning the business. It's equally important to plan how we shall relate as shareholders. Disputes are inevitable, and therefore it's important to ensure that we have well-drafted clauses in our articles of association that govern that would guide parties in the eventuality that there is a dispute. So my short presentation will cover the nature of companies, shareholder disputes that are managed by the Register of Companies, the different forums available for addressing shareholder disputes, what the role of the Register of Companies is when it comes to dispute management, and the ADR mechanisms employed by the registrar. So the legal framework is, so this role is really governed by a number of laws, and it's not a role that we simply carry out of the blue. There are laws that govern this dispute resolution function at the registry. Of course, the Constitution is the pillar of alternative dispute resolution. It encourages all quasi-judicial platforms to employ parties to settle matters by way of ADR. We have the URSB Act that establishes our mandate as URSB. So one of the core mandates of the Uganda Registration Services Bureau is to maintain an accurate company register. So the integrity of the company register is very, very key and fundamental to the functions that URSB carries out. So if you have managed to some way file a resolution which bears a fabricated signature or file a resolution without following procedural requirements, So, for example, when you file a resolution, it will state that you sat at a meeting somewhere at a certain date and resolved to do A, B, C, and D. So, if someone is ordinarily supposed to participate in that meeting, but they have not been invited to participate, okay, and you indicate them as a signatory on that resolution, the question will be, how did I sign a document if I did not attend the meeting in the first place? So procedural requirements like a notice inviting someone for a meeting becomes a key document, meeting minutes, attendance records. Now, these are documents that the Register of Companies doesn't ask for. We only ask for them if someone raises a red flag. So if there is a dispute, we will ask for these documents because we are interested in having a register which is clean. This register is relied upon by quite a number of stakeholders. It is relied upon by the public. Creditors rely on this register, including banks, where companies take loans, debt capital. We know that a number of companies survive on debt capital in Uganda. So if we have a resolution that says so and so is a director, yet actually they are not a director, or a resolution that says so and so has 50 shares in a company, yet that's not the position, then of course the effect of that is that all these stakeholders will be affected because they rely on this register. Of course, we have the minority member operation claims under Section 243 of the Companies Act, and Laston has really explained this in detail. We have situations where you have 3 shareholders in a company, you have 2 shareholders owning 90%, and another shareholder owning 10% of the shares in a company. And they get into a dispute, and of course, they do not agree. They can't come to some sort of a settlement or agreement. So the minority shareholder files a dispute here at URSB. So we are interested in ensuring that the company continues in operation. So usually what we will do in such circumstances is compare the share buyout where the minority shareholders, 10% shares, can be bought out by the individuals that own 90%. So we also handle those types of claims where we offer remedies that are alternatives to winding up. The nature of shareholder disputes that are handled by the Register of Companies mainly include minority operation claims, shareholder disagreements. Laston has explained what usually is the cause of these disagreements. We also have director and management conflicts. We have governance disagreements, irregular corporate filings. You have a resolution on file, but you did not follow the requisite procedure requirements before filing that type of resolution. And then we also have beneficial ownership disputes. So you know that it's now mandatory for all companies to file beneficial ownership forms. So if someone indirectly owns shares in a company but does not disclose that, that is currently an issue and it's actually a criminal offense. So the Register of Companies maintains a register of all beneficial owners in Uganda. So if you have a district official who owns a company and is awarding contracts to the company but does not exist anywhere on paper, it's not irregular for them to have a business, but it's important that they disclose that they have shares in that particular business. So as that district official awards a contract to company X, Y, and Z, it's important that they know that there is an obligation for them to disclose that they are a beneficial owner in the business. So there are different forums for addressing shareholder disputes. Of course, the first forum are courts of law. And of course, this is an adversarial setup where you have a formal litigation process before a judicial officer. The other forum is the Register of Companies, which is a quasi-judicial platform for resolving company matters. And basically, we resolve issues to do with member operation claims. We also handle issues to do with rectification of the register and investigations under Section 168 and 168 to 170 of the Companies Act. Now, ADR is an alternative to the formal adversarial process. So do you want your case to add to the huge numbers that are currently existing in court? Or do you want to have a discussion over your matter and settle it? How much time are you going to spend in this cycle of litigation? Remember, we are interested in your relationship as business partners. So one thing that is unique about company disputes is the fact that these are people on file that start out well. Okay, they start out a business well, and so they get into an issue, and at the end of that day, it's not like a normal corporate dispute, plaintiff defendant, where I will, a case will be completed and I'll go my way. Whatever decision a court makes, it affects you as a partner in that business. So it's important that you have a discussion around your dispute and find a middle ground on how to solve it. Okay? So take, for example, a dispute where a company, for example, you request for an investigation. What is the impact of that investigation on your company operations? Okay, so if an investigation is conducted and we find that, there are quite a number of audit queries in the business, and of course, this is information probably that would be in an inspection report that is accessible to your stakeholders. So what will the stakeholders think about your business or your company? Vis-a-vis what would be the advantage of having a discussion over that dispute and settling it, okay? Because your dispute will remain confidential, but at the end of the day, you'll get a solution that enables the company to remain in business as a going concern. So ADR then becomes a more preferred option to the adversarial setup. And we now have court-based mediation, where courts usually advise parties to start out by settling by way of a mediation. Then the Register of Companies is solving quite a number of disputes by way of negotiation and mediation. Then we also have private ADR firms like the ALP Dispute Settlement Hub, KEDA, ICAMEC, and so many others are coming up. So it's important for parties to make use of these different platforms, okay? What are the benefits of ADR in shareholder disputes? So before probably I talk about that, we'll look at the role of the Registrar of Companies in managing shareholder disputes. So our role is simple: to maintain a register that is accurate. So if you have a document that is filed and it has an issue, definitely we will have it expunged. So what's the role of ADR in this? As opposed to having a fully fledged setup where you have a formal hearing, I issue schedules for submissions, this is not going to take 2 weeks or a month. It could take probably at most 2 months. What about we come into a room, talk about that particular document that has issues, and if indeed the document bears a fabricated signature, we get a settlement from the parties recognizing the fact that there is a problem with that document. You see, the beauty with companies is that even if we expunged it, you can still go back and follow the proper procedure to file the very same document on file. So you find that if we go through a settlement procedure, it will give you the same results without necessarily taking a very long period of time to have the dispute settled. But also you find that I will not publish your decision on these different platforms on Yuli, and I will not type in your company name and find that you had issues to do with fabrication. So the confidentiality of the proceedings is also safeguarded in that way. The role of the registrar also involves monitoring statutory compliance. If your company has to file annual returns, ensure the returns are filed. If a company has to file audited books, please ensure those books are on file. Whatever is on the register must mirror what is practically on ground in the company. It will save you a lot of trouble in case you get into a dispute. The ADR process before the Register of Companies. So the Register of Companies under Regulation 34 is encouraged to refer parties to mediation or other forms of ADR. And once the parties agree to settle, we will have a settlement agreement filed at the registry, and that is a binding decision on the parties. But if there is no settlement, then of course the registrar determines the matter, or in appropriate cases refers the dispute to court. What are the benefits of ADR in shareholder disputes? One, your relationship is preserved, okay, because it creates a win-win type of situation. Of course, there is lower cost. There is less formality. For example, if it is negotiation, as a form of ADR negotiation, we do not actually facilitate that discussion. We allow the parties time. We give you space in a boardroom. You sit and talk over your matter. Okay. Once you resolve the issue, you will then file either a withdrawal of the matter, which is what we call a notice of withdrawal, or you file a settlement agreement. So you find that there is lower cost, less formality, but also your relationship is preserved. Confidentiality. You can imagine if you own a company and I need to hire that company I need to give you business, and I Google the company, and the first thing that comes up is you people are fighting, you're forging each other's signature. It does not augur well with me as a third party. So if you settle your matter, of course, these are things that sometimes we cannot avoid. Disputes are inevitable, especially in the business context. But once the dispute arises, it's important that you adopt a forum that will keep those proceedings confidential, especially in the context of corporate governance. Reputation is key. Reputational risks can damage your company. So if you have issues to do with of course, if you do not settle and we have a formal decision, that decision will be Hello, am I back?
Yes, you are.
Okay, good. Okay, so there is faster resolution, and you find that ADR also supports business continuity. So in conclusion, the Register of Companies role has evolved into one that requires dispute resolution facilitation, and there are quite a number of modes of ADR. There is negotiation, there is mediation, conciliation, arbitration. Arbitration is a court process out of court. So I would implore us to look at these ADR mechanisms in that order. Start with negotiation. If negotiation fails, look at mediation. If it fails, then you can probably opt for a formal decision, either from a quasi-judicial platform like the Register of Companies, or take your matter to court. ADR improves access to justice for disgruntled shareholders. It reduces court congestion and backlog. It promotes investor confidence in the business environment. Of course, if investors know that the Register of Companies will not maintain a document, a form that indicates false directors, they get confidence in dealing with our register. But if we have registers that bear fraudulent entries, then definitely the stakeholders will have an issue with the information that we give them. This register is fed by companies, okay? And it's important that we safeguard. We are at the entry point, okay? The register of companies is a watchman, okay, of the register. So please understand us when your documents are queried, when we return documents, we are trying to ensure that we maintain a clean register. So thank you all for listening to me, and hopefully this discussion has been quite helpful in the context of the registrar's role in facilitating alternative dispute resolution. Back to you, Suki.
So much, Danielle. Thank you for a very insightful presentation. As we begin our next session, if there's anyone that has questions, please share them in the chat so that we can receive them and answer them later. So for our next session, we'll have a few follow-up questions for our presenters. Just picking up from where you stopped, Daniel, from your perspective, your viewpoint as a registrar, what are some of the most common causes of shareholder disputes that have wound up on your desk?
Thank you, Lucy. That's a very good question. So the most common shareholder disputes really revolve around minority operation, unlawful removal or appointment of directors, disputes over membership and transfer of shares. People forge documents transferring people's shares. Okay, denial of access to company information. We also have the issue of deadlocks that was explained by Laston. Deadlocks in family-owned businesses, irregular corporate filings. So those form the batch of disputes that we handle at the registry.
Maybe just for the benefit of our participants, some of whom may not be lawyers, what does a shareholder have to do for it to be categorized as minority oppression?
Yes, so minority oppression, simply put, is a shareholder who owns in terms of numerical numbers. I own less shares in the business, so that's the beginning point. So if you own less than 50%, okay, you have people that own 51%, you become a minority in terms of numbers. But there are also quite a number of cases that have exemplified the context of minority, not simply in terms of numbers, okay? So I could be a majority shareholder in a business, but you find that there could be 20 shares, but you have each of that share is owned by an individual, okay? I own 80 shares in a company, but you have 20 shares and each share is owned by one person. And you see, if of course we are voting on a poll, I will take that day. But in the context of oppression, we are not simply looking at voting, okay? We are looking at oppression in terms of misuse of company information, denial of access to information. I'm a majority shareholder, but I've been denied access to my business. I cannot access the premises, okay? These things are quite surprising, but they actually are happening. A shareholder is denied access to their premises. We also have family-owned businesses where people did not actually contribute shares to the business, but somehow maybe their parents gave them each five shares in the company, and maybe I was the elder sibling and I got 10 shares, okay? So on paper, I have more shares in the business, but I now have to deal with my siblings, and we are getting issues because maybe one of our parents is now deceased. So if you look at it in the context of the numbers alone and dismiss such a case and say, but you own majority shares, you own 80 shares and your siblings own just 20. So this is not a case of minority oppression. You would have missed the case and not offered justice to such a shareholder. So any person who is a shareholder in a business and they are generally frustrated by how the business is being run in the context that they cannot exercise their membership rights qualifies as a minority for purposes of Section 243.
Thank you, Daniel. Over to you, last one. From our discussion, it has become very clear that often escalation of disputes results from either improper documentation, improper shareholder agreements, where the dispute resolution clause or the dispute management clause is not exhaustive. Disputes escalate when we do not plan for what should be foreseeable. Could you take us through what a comprehensive, proper or tiered dispute management and resolution clause should look like?
Well, thank you, Lucy. In the short time we have, I want first put a disclaimer that it may not be possible to go through comprehensively what a tiered dispute escalation clause should have, but I'll just give highlights and pointers. As Daniel has been going through the practical perspective of what the registrar actually deals with when these disputes arise, the point where even the registrar is going to intervene to have that kind of informal meeting where I say, let's look at this document, for example. Does it bear? I want to pick it up from there. That is, does it bear for signatures? If it is agreed, say the same thing can be achieved by you going back and this time you follow the right process and procedure. So when a dispute, a disagreement arises among or between shareholders, the first place to look at, since we are dealing with the company, is that the company has governing documents. These documents will include a memorandum and articles of association, which at least here in Uganda, you can't incorporate a company if you don't have the subscribers at the time who are forming this company signing onto memorandum and articles of association. However, when the company now, like Daniel said, take more time in preparing how the relationship is going to be governed and it's going to coexist. I loved what Daniel put emphasis on. You take time to be able to shape how, in case we have something we are not seeing eye to eye, how do we go about it? First and foremost, yes, have a proper dispute resolution and dispute avoidance clause. What should it have? In my earlier presentation, I tried really to just quickly hint about it, but I'll say this again. An ideal clause should at least have an escalation pathway. If an issue has arisen, we are disputing over a resolution, we are disputing over a decision, we are disputing over how the company is being managed. You need to know from day one that from the time the dispute has arisen, this is the way or the path that we are taking. For example, one, there has to be a notice. People will not know. For you may be assuming we have a dispute when other shareholders don't know that they even have any dispute. So that kind of dispute escalation, avoidance or resolution clause, it should at least preliminarily provide for notifying the other shareholders or other stakeholders in the company that this is the concern that I have, and in my view, it is a dispute we need to attend to. And there has to be a clear timeline. When are the other shareholders or stakeholders that have been notified, when do they reply? For a litigation lawyer, I would say this, that one of the ways that disputes are frustrated to be resolved quickly and amicably, and Daniel was warning us against that, is when we come and say, let's agree on schedules, timelines. Then I'll ask for 2 months. Then the other will ask for another 3 months. Before you know it's half the year. Before you know it, it's 1 year, 2 years, 3 years. So a dispute resolution and avoidance clause must have clear escalation timelines. I notify you. There has to be a timeline we have agreed on in the document that requires me to respond. And then there has to be a consequence. If I don't respond, then what is the next stage? my view would be don't run to court directly after they have not responded. Don't run to court directly, provide at least either for initiation or maybe a negotiation of sorts. If the parties have communication that has completely broken down, involve at least maybe a mediator or an expert, a third party, bring in a third party. You can have them as a conciliator, they can be a mediator, they can just come in to enable the parties now sit and begin talking to each other without running quickly to court and so on and so forth. And that also must have a timeline. Probably if negotiation fail in the 21 days, we can maybe in the next 14 or 30 days go for mediation. This really is on a case-by-case basis. There are some disputes because of their complexity that certain timelines may not be ideal. Yet there are disputes that are so simple that even 1 week, 1 month of leaving the dispute hanging is really affecting the business in a bad way. And Daniel said, if I search, I want to do business with you, and I search, and the first thing I'm seeing, these guys are in court, there is a cause list in court, there are like 10 rulings from the registrar about one dispute after another, no one will want to do business with you. So when you have tried what are more of informal resolution of disputes, and they have not, those mechanisms have not yielded to a conclusive result, begin thinking about some formal mechanisms. And that's where issues like arbitration come in. Now, the moment you go down the arbitration line, and Daniel will tell you, you will have companies that have arbitration clauses in their agreements, but the arbitration agreement is not properly done. An arbitration agreement, that one, does not provide for an effective way of appointing of arbitrators, becomes difficult to enforce. It becomes difficult to put in effect. So the arbitration agreement must expressly provide for when do you trigger arbitration, because it's an escalation pathway. Trigger arbitration after what time period? Trigger arbitration when the initial attempts to resolve the dispute, either by negotiation or mediation, have failed within the prescribed timelines, and then you go maybe now for arbitration. When you're going for arbitration, one, there has to be a valid arbitration agreement or clause in your document, which must at least provide for the following. Like I said, we don't have enough time to really go through all these arbitration, ideal clauses and standard clauses that are some in some of the international arbitration instruments. But at least say that we are going to resolve the dispute by over arbitration. It means you're choosing arbitration as the fora after these others have failed. Two, you must provide for how the arbitrators are going to be appointed. Are they going to be party appointed arbitrators? Are we appointing a sole arbitrator? Are we appointing a panel of arbitrators? How is the appointment going to be done? Then you must also provide for the law that is going to govern the arbitration. There are different rules that you can adopt. You can adopt rules that will guide the arbitration proceedings, because the agreement that you have, like Daniel said, can be governed by the Companies Act as the law in Uganda that governs affairs of the company. But when it comes to the dispute resolution mechanism, there are different other rules that you can adopt that will govern your arbitration. And in there, they will also have certain guidelines on what you're required to do if a party is not maybe complying to the procedures of party appointment of arbitrators, if a party is not consenting, a party is not giving and participating in what you agreed to do as the dispute resolution mechanism. Number 4, the arbitration clause should also tell us where is the arbitration going to be held, the seat of arbitration and the venue of the arbitration, where. Some will say, because I'm in India, come to India. And it's very expensive for you from Uganda to fly to India. Some will say, because we are both, I'm from Kenya, you're from Uganda, let's go to Tanzania. And then before you know it, it becomes expensive to actually proceed with the arbitration, because all parties are from different jurisdictions and they are flying in. Provide that even the arbitration can actually be held online because of technology today. Some of those considerations help you to foresee that the dispute can be resolved in the most cost-effective way. You have also to provide for the language, because If you have like, cross-border disputes involving investors from different countries, someone say, I'm from Germany, I feel comfortable that the arbitration be, done in German, but your governing documents are in English, because at least if you have a document that is in Chinese and you want to register it with URSB, the last time I checked, they are going to require you to translate it. So those are things as an advisor, as a shareholder, as a business owner, you want to consider. The language, you have to be clear as to the language that you're going to use. Bottom line, arbitration also has its challenges. Make sure that when you're appointing arbitrators, you appoint arbitrators whose integrity is not questioned. Otherwise, when you're dealing with arbitral awards, setting them aside, registering them, it can be a protracted thing by its own self. The point is, from experience, litigation, like Daniel said, that the decision that is made is going to affect you as an owner of the business one way or the other. It's not ideal to just run to court for litigation over shareholder disputes without first exploring what we are calling an escalation pathway. Try these steps. Before you know it, what had broken down in communication can be restored in a mediation meeting. What had broken down in a misunderstanding of the figures can be restored. If you have an expert, do maybe a forensic something for you to look at and give you an independent report to tell you, by the way, this is what the figure means, this is what the sales mean, this is what the loan means, this is what the capitalization of the business means. So by and large, Lucy, from where I sit, the ideal escalation matrix may not be a one paragraph that we shall resolve our disputes under the laws of Uganda. That leaves it open. And you cannot also say that we shall agree to the dispute resolution mechanism when the dispute arises. That is not ideal. Set these things beforehand so that if or when the dispute arises, you have a clear guiding manual on what the parties would have agreed to. That is at least what the best I can do within the limited time. Thank you. Thank you, Lucy.
Thank you so much, Lester. Now, from your discussion, it got me thinking, are there instances where the dispute resolution or dispute management clause conflicts with the powers reserved in the law for the registrar? And this is for you, Daniel. And in such scenarios, how does the regulator handle it?
Yes, Lucy, your question is whether there are situations where you have a dispute and a party needs to decide which forum is best for them to resolve it. Is that your question?
The question is, where the parties have in their shareholders agreement or articles of association chosen a dispute resolution mechanism with respect to disputes, which would otherwise say oust the jurisdiction of the registrar. How do you handle scenarios like that?
Okay, so you say we have a clause that says the register of companies shall not intervene, for example, in a situation of rectifying the register. So that would be a dispute resolution clause that would be null and void, because an arbitration clause cannot oust the jurisdiction of court or the jurisdiction of quasi-judicial platforms. So if you have such a clause that says the registrar can't rectify the register, we will unfortunately not honor that clause. So it is important that while parties draft these arbitration clauses, they draft them with the guidance of legal personnel. There are people that have gone to school and qualified in this area of ADR. There are people experienced in this subject of ADR. So in as much as you want to be convinced that this is simply a clause I should paste from one document and put in my, articles of association, please, it will bite when the dispute actually arises. Okay, so it's important that if necessary, the parties get the necessary legal advice before incorporating these arbitration clauses in their articles of association. We also have general arbitration clauses where a party says, in the event that any dispute arises, okay, we shall refer it to arbitration. But now the dispute you have before the register of companies concerns rectification of the register. So if I have a fraudulent resolution on file, okay, you have transferred people's shares, they have not signed, you have removed people as directors, you have not followed the requisite procedure. We now have the practice of, unfortunately, even lawyers cutting and pasting signatures in documents, looking for shortcuts. These shortcuts are good. Of course, you will have your way. People are smart and the document will be registered. But when a dispute arises, unfortunately, things will not go well for your client, okay? Because your client will not be happy that you pasted a signature, but also secondly, they will now see that what you did was, it's actually a criminal offense to cut and paste a signature. We have clients that have pursued civil remedies here, we rectify, but also go ahead and pursue criminal sanctions, okay? Because forgery and uttering a false document is an offense under the Penal Code Act. So on top of rectifying the register, someone also pursues you before the DPP, and you find the agent actually, you can imagine getting imprisoned. And Lucy, this is something that has happened. This is not just a story I'm picking from anywhere. We have people that have been arrested over something as simple as forging a signature on a transfer form. We know that shares are property. And for some of these companies, one share is worth billions of shillings, okay? So as you forge that transfer form to transfer somebody's shares, please be aware of the repercussions. So if you draft your arbitration clause that says the registrar can't rectify, unfortunately, we shall not honor the clause. Our mandate as a registrar of companies is to maintain a clean register. Anything that really appears on that register that is a fabrication cannot stand. And this is not just up to the parties. So what I'm saying, Lucy, is that the parties cannot even enter an agreement that says we have now both agreed to keep this fabrication on the register. Once it is proved that it is a fabrication, we expunge it, then you go and file the proper one. Okay, so that is not possible. You can't draft an arbitration clause that oaths the jurisdiction of the registrar. However, we have situations, especially those that fall under Section 243, minority operation claims. So those cases, usually we can refer to arbitration. Okay, so the registrar does not arbitrate. Maybe I need to also make that clear for the participants on this call. We do not arbitrate as a regulator. So the best we can do is look at your clause and refer you to the ALP Hub Dispute Settlement Center, or refer you to KEDA or ICAMEC, or tell you to sort your issue with an arbitrator, because that's what your clause says. But it depends on the nature of the dispute. So if the dispute says a minority operation claim, and you say you want to go to an arbitrator to settle it, there's no reason why the registrar should proceed to give you a decision on it. We shall refer the matter to arbitration. But on compliance issues, irregular filings, your company has not been paying returns, we strike you off or deregister the entity. Those are really, you can't boost the jurisdiction of the registrar with your arbitration clause, unfortunately.
Thank you, Daniel. That's not exactly unfortunate. It just calls for more caution as we draft and prepare. And thank you for the reminder that you're referring people to jail. I think as for me and my house, which is ALP, we shall not be going to jail. But as we advance this discussion, could you maybe guide us? Now this is for you, Laston. How do you choose the most appropriate dispute resolution mechanism? Are there some that are better suited for, say, shareholder disputes than others? And with that, what do you do when the relationship has broken down completely? Let's say I've done my part, I've put in the tiered dispute resolution clause, but we're no longer able to speak or communicate or even send emails. How do we go about that?
Wow, thank you, Lucy. And essence of having such a clause is not that you want your relationship to break down, but in the event that it breaks down. So by the time you get to the place of the last part of your question, by the time you get to the place that we are not speaking, it's because you have that well laid out pathway. What shall we do? How shall we go about our disputes when we are not able to speak, when we are not able to communicate? You go back to the documents that bind you. And that's why that if we find that if we find that in your documents there are these particular provisions, will refer you there. And he made a very clear distinction, except for things that are not subject to arbitration. Fraud per se may not be subject to arbitration. Breaking the law, I don't think it will be subject to arbitration. And rightly so, Daniel has made that clear. So, two things. One, if you find yourself that the relationship has broken down, it goes back to the advice Daniel was giving us that if you had taken time planning for how the relationship would be governed, even in the difficult times, marriage is not about only good times alone. And that's what business sometimes is about. How do you deal with the brutal facts when there are these confrontations you have to deal with? If you have a document that says that this is what we agreed to do, any basic lawyer will tell you in the law of contract, if that is what you agreed to, you are bound by those commitments. And because you're bound by those commitments you made to each other, it will be difficult, Lucy, for someone to say, I just don't want to do this anymore. There are other compliance mechanisms that would be used to actually force you to comply with your own agreement. That's why if a matter goes to court and court is told, we have a this dispute resolution clause that requires us to go to arbitration under Section 9 of the Arbitration and Conciliation Act, court will say, we'll stay the case, go to arbitration. Even if you don't have an arbitration clause and maybe you have a mediation or any ADR clause, today in our civil procedure, you're going to be told, as you're filing these cases in court, prepare to actually even go for court annexed mediation. But the discussion we are having today is how do you avoid spending money even going to court when there is a cheaper way of resolving the same dispute? Two, are there dispute resolution mechanisms that maybe are tailored to shareholder disputes? I will say that probably not per se. Each shareholder dispute is likely to be influenced by the nature of the company and sometimes what is at stake. Now, if you're dealing with a share which is in billions, the way that dispute is likely to be dealt with more so when the financials and investments are at stake. You can think that someone is a minority shareholder, but they are a minority shareholder in a company whose value and assets are in millions of dollars. So that kind of dispute and the stakes may not be just because you are terminating a director I nominated, therefore our relationship is breaking down. It could be that there are interests that shareholder needs to be protected by having the director appointed in the manner in which they agreed. That by not doing so, they fear that because they're a minority shareholder, as more investors come, their voice will never be heard. So maybe even what the shareholder wants to protect is far much more than what the law can answer. So the question would be, what would be the appropriate dispute resolution mechanism? In my humble experience, and from what Daniel shared, you want to choose those dispute resolution mechanisms that, one, are cheap. There is no client who wants to go for an expensive dispute resolution process. They can say, let's go to Singapore, until you tell them, okay, this is the bill to go to Singapore. We have had some of those experiences where clients say, let's go to London to arbitrate. Say, okay, they don't want to hire lawyers in London. They want you local counsel to go there. They don't want to pay your air ticket. Then they realize it's so expensive. What you do as lawyers, counsel to counsel, you sit down, you negotiate the thing, you cut the costs, and then you enter a settlement, and you just sign a settlement, even when it's really outside court. Bottom line, really, Lucy, is the reason as to why ADR is preferred. Do your research, anyone here. You'll find that alternative dispute resolution in shareholder disputes is more preferred because it preserves the relationship among or between shareholders as opposed to the adversarial litigation. It also carries with it a certain level of confidentiality. Daniel was telling us that the disputes that are resolved in their boardrooms with the shareholders sitting together, you will not find their rulings anywhere online. But yet a dispute would have been de-escalated, it would have been resolved. So it provides that confidentiality. 3, it restores that you put the actual face to the dispute and you talk through certain emotions. You know, court is not emotional. Court will not hear your emotions and cries. Even when you cry, it will go by what the law says, what the facts say, and what the precedents say, and then they will decide. Here, shareholders actually are able to appeal to each other to even resolve those underlying and heal the wounds that otherwise will not have been healed in another dispute resolution process. And finally, for me, what I've picked from my experience is that sometimes all people need is to take time and heal. Now, when you're in litigation, as you know, ICMIS is issuing these notices, appear here, appear there. Every hearing notice is reopening a new wound. Yet, when you are dealing with your alternative dispute resolution, you agree where you're even going to sit. Court will not come to where you are. You have to go to court. In ADR, you can even agree, we'll sit in a place where each one is comfortable, we'll meet in middle ground. Maybe we'll go to a lawyer we trust, an accountant we trust, a mediator we trust, and there is that level of trust that ADR gives you in shareholder disputes that probably litigation by its design, honestly, may not be able to give to you. Finally, when you end up before the regulator, such as the registrar, I have had the unfortunate incident of, handling some disputes before the registrar, and I'll be honest, the spoiler alert, it was us lawyers who were frustrating the clients. The registrar tried, Daniel's team tried, and we were speaking our nice English years down the road. Unfortunately, that dispute has not been resolved. The clients are frustrated. We are waiting for ruling on Lucy, don't laugh, but we are still waiting for the ruling and still praying for Hail Mary. Why? We missed the opportunity of resolving this dispute when we were before the registrar. Unfortunately, some shareholders have passed away, directors have passed away, the company still exists, the dispute is still alive. So ADR would be really, as much as it's possible to persuade shareholders to be worth considering any form of ADR that suits them, that is cost effective, gives them time to talk, and also redeems their relationship that would have otherwise broken down. Thank you, Lucy.
Maybe, Lucy, just to add on what Laston is saying, colleagues, if something is a disagreement that is not really very substantial, a minor disagreement, and of course I know I'm speaking to lawyers and they will say what disagreement is minor and what is major. But really, if you're dealing with a disagreement where your client simply says, my signature appears on a document and I did not participate in that meeting. You don't have minutes. You ask your client for a notice inviting that person for a meeting and they do not have it, okay? It was not a written or circular resolution. For private companies, we have circular resolutions where we don't need to sit in a boardroom to sign a document. I'll find Lucy where she is, I'll go and look for Laston, and we shall sign as directors and submit, okay? But we are dealing with a situation where my signature appears on a resolution on a transfer form, but I did not attend a meeting, and your client does not have minutes, does not have an attendance record. It was not a written or Robin circulated resolution. Now, what business do you have taking such a matter for formal determination? Because you do not have the requisite documents. Now you're going to tell me you're going to generate them post-dispute filing. You can draft the minutes, you can draft the notice. My friend, these documents are supposed to be served. So the notice, if you're saying someone attended a meeting, did you serve the notice? Do you have proof that you served it? So such a simple dispute, in my view, would be a minor dispute, which can be solved by negotiation. Sit down with the parties, communicate, reach a consensus, agree, let's have the document expunged from the file. But if the parties' relationship, so Lucy's question was, how do we determine what is the best mode of settling the matter? So if the parties can still talk, okay, let them negotiate, reach a settlement, or if the party really attended and signed and there are documents for that, they can as well file a notice of withdrawal of the matter they filed. But if you're dealing with a case where the party's relationship has irretrievably broken down, okay, like some marriages, okay, where parties can no longer talk, they can no longer, people who used to move together in a vehicle can no longer sit together in a vehicle. Really, you're dealing with a situation where if you left them in a boardroom for a minute, they would fight each other. So if the relationship has come irretrievable, and there are ways you can, unfortunately, we don't have time, but there are ways you can ascertain that these people really can no longer talk. Then you incorporate mediation, because now there will be a third party who is trained. Okay, well, a mediator can be anybody, but in this context, I'm talking about trained, because shareholder disputes are not like any other disputes. They require some technical knowledge. So you're talking about someone who is experienced, who can caucus with one of the parties, bring tensions in the room down, and then eventually we get the parties talking, okay? So you facilitate or perform an evaluative function. So if the parties are no longer talking, then go for mediation. Then if you need proposals from the parties, file your settlement terms, and then we'll agree on a settlement agreement. Then that's conciliation, okay? But you also have situations where you have a contract, okay? And people are no longer talking, okay? But they also want to keep their proceedings confidential. So they don't tell them about your mediation or negotiation. All they want is a binding decision. But they don't want that decision of Daniel that is going to appear on Twitter, on Yuli, and all these different platforms. They don't want a decision from a judge that is going to appear on all these different platforms, okay? That today we still refer to parties cases, Matthew Ruchikaire versus Incafex, a case that was decided over 14 years ago, but people in law school still cite the case, okay? So the confidentiality in that case becomes key. So go for arbitration. It will give you what a judge would give you, but safeguard there will be some sort of privacy. So when I Google the company, I will not be able to see that you fought over shares or that kind of thing. And then I'll be able to trust the company with my business. So that criteria should be able to guide us when we are determining which method of ADR is the most appropriate.
Thank you so much, Daniel. Thank you so much, Laston. Again, to the members, participants, if you have any questions, in the interest of time, please share them in the Q&A. So far, we've received a few questions in the Q&A. The first one is an actual scenario. Someone's asking about a family-owned business. Laston, please prepare to respond to this. A family-owned business where two family heads form a company, but they include shareholders like their spouses or their children who have not actually paid for these shares. And you also find that one of the siblings holds shares on behalf of other siblings who are not listed in the company records. Now, the principal passes on and disputes arise relating to the distribution of the estate. So even where there is a will, you find that maybe the will is mentioning beneficiaries who are not members of the company. The question is, how do you deal with a matter like that on the level of a family, but also on the level of a company? I will take both your perspectives on this for Laston and from Daniel as we try to wind up this session. So let's start from Laston.
My honest answer, get a good corporate lawyer to give you a legal opinion on that matter. That would be my advice. Get a good corporate lawyer to give you a legal opinion on that matter. And it's because it's a convoluted issue. It's a convoluted, straightforward. Let me give you off the cuff. if your name is not in the company's documents, when you go to Daniel is going to ask you, are you a member of the company? If you're not there, yeah, that is it. Two, if the person who passed away, the founder of the company passed away, that triggers another law, succession. When you go to Daniel, you RSB, I'm here, this person passed away, they were my father, I had shares in there, they will tell you there is another law that governs that process of succession before triggering transmission of the shares to the legal representative, which legal representative then has to distribute those shares to the ultimate beneficiaries. So you realize that you need to break down the problem and then deal with it stage by stage. For example, you know that there is this principle of law that a person can benefit from a contract which they are not signatory to. A company with its documents, those documents are binding on the company and the shareholders. When you bring in now succession, are we dealing with you as a beneficiary under an intestate estate, or are you a beneficiary and a will to whom maybe certain interests were bequeathed? When the beneficial owner, Daniel talked about it, when you're being asked for the ultimate beneficial owner of the shares in the company, who has declared? So if your BO form does not name anyone who is claiming to have shares in this company, it means what you represented to government, let me be honest with you, is that the people listed here are the ultimate beneficial owners. If your name does not appear anywhere in the memos, not anywhere in the register, it's going to be difficult for you to come and directly now assert that I hold shares in this company. However, through succession law, if any of those shares, upon them being transmitted to the legal representative, they are distributed to you as a beneficiary in the estate, then definitely you will later become a shareholder in the company. If there was, for some reasons, the shareholding in this company was structured not to have certain siblings, not to have certain children who belong to the deceased as part of the company, it may be difficult post the death of the founder of the company to say that my father, my mother, my uncle intended that I be a shareholder where there are no documents to it. In succession law, as I conclude, there are gifts, what we call gift inter vivos, a gift given during the lifetime of the donor of the gift. And then in wills or succession, when a person passes away, there are bequests that are done either in someone's will. So your scenario, what do you do? How do you go about it? Deal with the succession issue under family law by getting probably the letters of administration, you get letters of probate. Deal with defining who are the beneficiaries in the estate of the deceased. The estate merely has interest in the company. The company is not the estate per se, because you're saying there are other shareholders in the company, and it means the company, of course, survives the death of the deceased. That is one. When it comes now to the company itself, who is the shareholder? Look at the documents of the company. They should be able to tell you, are there any trusts that had been created maybe when these people were being given to hold these shares in trust? But if you introduce the issue that I hold shares in trust, Daniel on this other side will tell you, but you didn't tell us that these were the ultimate beneficial owners when you were saying they were holding shares in trust. So it's a complex one, I agree, but there is a way out about it by dealing with the different areas of law separately. Thank you. Over to you, Daniel.
Yes, thank you, Laston. Now, that's a very good question that is in line with our topic today, mediation. Mediation, negotiation, let the parties talk about this issue, because you see the parties know the truth in this case. This is a business, they are family, they were given shares, they did not contribute in terms of contributing capital to the business, but it's just that one person is fortunate enough to appear on the register as a member and the rest do not appear as members on the register. When you come for a formal decision, when you go through, let's say, the quasi-judicial platform of the Register of Companies, or better still, you go to court and litigate this matter, if we look at it in the legal lens, as Laston is saying, you will get a remedy. Of course, the remedy will be that one party will win and the other will lose. But isn't that going to destroy the family relationship? That's why in the beginning of this discussion, I said, let's work towards preserving relationships and what is the most appropriate fora for ensuring that. In my view, that fora is mediation and negotiation. Because you see, for this, actually, this problem is best exemplifies why negotiation and mediation are important in dispute resolution. Because these siblings know how this probably could have been the firstborn or the heir, or probably at that time he was old enough and was working in the business with the parents. And we all know as lawyers how our parents actually not that conversant when it comes to registering some of these companies. Some of them don't get good advice. Unfortunately, sometimes we misadvise some of these people when we are registering, and we include ourselves as shareholders and we tell them it's not a big deal, okay? And we get it registered. But we know the impact of that in terms of the law. But of course, we look at if, as Laston is saying, the registrar will ask, are you a member on file? If you're not a member, probably you don't even have locus under Section 243, okay, to file a petition because you're not a member. And I have a plethora of cases that fall in this bracket. I don't know if the person who asked this question is an affected member, okay, where you have families, the members don't appear, family members don't appear on the register, but they say, you know, everyone knows it's in black and white that we are actually beneficiaries of this company. And we all know that now people use companies as succession measures, okay? Especially people that don't want to go through the route of making wills and that kind of thing. You just make a company, put in your children, your wife, and then register it. Now, sometimes you register a company, but situations change. You get a hacky number two, get another child probably who you did not envisage, but you don't come back to update the register. So we keep a register that has 2 children, but at the time of your death, you have 14. Okay. And of course, the 2 children are now claiming that we are the ones entitled because we are the ones that appear on the register. And indeed, if you look at the law, probably you will win. But it's not about winning. Okay. It's about justice. So if you know, and as a lawyer, really, this now falls on us as lawyers. I know we are arguing our clients' cases, but are you helping the clients achieve justice, or you're sending them into a war room where they are going to fight forever? Because these siblings will never accept that decision, okay? Whichever decision is made by a judge or by a registrar, they will never accept it. They will fight until I don't know when. So you find that in that context, sitting them down and discussing with them and say, well, you have these 20 shares on file, but can we talk about it? Because you have siblings, okay, who are also entitled to this property. So maybe we give you letters of administration, as Laston was saying, and but what are you transmitting in that case? Because this person has the 20 shares already. So maybe if the parents had 50 shares, we can have the 50 shares now. So you have a middle ground. You already have 20. We have a case where a child was given 10 shares, but they also are saying as a child, they are beneficiaries of the balance that was owned by the parents. And we had to sit them down and say, no, look here, your parent already gave you 10. Now you have 5 siblings. Can't we find a middle ground on how maybe we have this balance that is owned by the parents transmitted to you, let's say, but in trust for, or we transmit directly to these other siblings, such that they also come on board as shareholders. So that's the power of negotiation. That's the power of mediation. We are not talking about which section of the law, which precedent. We all know that sometimes I'm sure you have read decisions and then you say, okay, but this one. But it's a decision, it is there, okay? But will it solve the client's issue? So I think this question is one that can best be resolved through a discussion with the parties, of course, within the confines of the law. And for us as a registry, we are open to this as a mode of settling disputes. And my experience, as I conclude, Lucy, is that really parties walk out of the boardroom with smiles. They walk out shaking hands, and you solve an issue. And also in terms of as government benefits, because when a company fights, when a company is involved in disagreements, they will eventually, the end result is winding up. We are the same office that winds up these companies. And majority of them, these are things that could have been avoided. Okay, you find the companies winding up, they sell assets, sell property that people have spent years building simply because of a simple disagreement like this one. So my advice to this, whoever asked the question, I don't know if you have a matter before this office, but I would highly implore you to first seek out an amicable settlement of the matter. Of course, if it fails, then definitely we will have a formal decision made. But if this is a good case for ADR. Thank you, Lucy.
Thank you so much, Daniel. Thank you so much, Laston. You know, this is a practical scenario which is very common in our country. We lose many businesses to improper succession procedures, especially where companies involve families. The two are intertwined. It always gets very, very tricky. But all these things can be avoided. Why? It's not unforeseeable. So when you're preparing as a lawyer, or also as a shareholder, when you're preparing constitutive documents for a company which is also intended as an estate vehicle, why would you adopt generic memats, which, for instance, will outrightly disallow any shares being held in trust? You need to be specific, you need to be intentional. Think about the business, think about the objective. What are you trying to do? Are you trying to preserve an estate? Are you trying to just set up a company? So the relationship of the parties should be well captured in the documents, the various documents that would have prevented a situation like this, including family charters, properly written will, properly written shareholders agreement, which acknowledges that their shares held in trust. So again, it comes back to the documents, the underlying documents. I know that most times when we are starting out, the relationship is good, but you look at the documents as the fallback, a safety net, so that when the day when the relationship is strained, there is still something that can guide the parties to a decent resolution. Maybe the other thing I picked up as Daniel was discussing is that sometimes when it is a family matter, emotions tend to flare, and mediation, when you think about it, with a mediator who is probably close to the family, might not be the most viable position. Sometimes the parties need to really feel that they have appeared before someone completely impartial. So even when you're considering possible mediators, have a broad perspective. Look for someone who can actually take charge of the room, who can help both parties control their emotions rather than flare them all the more. Anyway, that's a very lengthy matter. Just to give the rest of our questions an opportunity, there is one which I think the registry will note concerning the search reports. We'll just forward it to URSB. Someone is asking, Daniel, what is your take on a shareholding between two people? Should it be 50-50, 60-50, maybe they meant 60-40? But in summary, is there a particular shareholding structure which, in your view, would avoid disputes? Maybe just briefly you could answer that.
No, there is no particular shareholding structure that will avoid a dispute. Because a dispute can, even a majority shareholder, as I explained in the beginning, can also be frustrated by minority shareholders. Okay, of course, ideally in the law, we anticipate that they can vote, and so we don't expect them to file a case because they are the majority. So they can sit in a meeting and vote out the minority. But we have situations where you have in terms of physical numbers, the minorities are quite a number of, and they outnumber the majority shareholder. So if you had a 50-50 or 60-50 shareholding, of course, ideally when you look at Section 243, and it aids a minority shareholder who claims they are oppressed. So the first issue would be whether if you are a minority, you qualify under Section 243. Ideally, we would expect the majority to pass resolutions, so we don't expect them to be frustrated or oppressed, okay? Because they are the majority. We expect the majority to frustrate the minority shareholder. So if you have 60% shares, you would have the onerous task of now proving to the registrar that while you own 60% shareholding in the company, there are circumstances that have put you in the bracket of an oppressed shareholder. Okay? Otherwise, if you don't lead evidence that shows me that you are a majority but you have been oppressed, I will most likely dismiss that matter because I expect that as a majority, you should be able to pass resolutions that but we have situations, Lucy, where you have two shareholders, okay, in a company. Let me even change it. I own 90 shares and someone owns 10 shares, but they have refused to sign resolutions. And the registrar is saying, I will not register any resolution if your colleague does not sign, okay? So this person frustrates company operations. They are not signing company documents. The company needs to borrow money from the bank. They are not signing resolutions, okay? But this person is a majority shareholder. So that evidence, that sort of frustration can allow me, while you are the majority, we can compel a share buyout to avoid such a deadlock, okay? We also have situations where you have 50-50. So who then is a minority in that context? But you have a case where someone is a shareholder, they don't attend meetings, they don't contribute money to the business, but when the profit comes in, they want to benefit. That is unjust enrichment, okay? So on file, you have 50 shares, but you don't want to participate in running the business. So that then becomes a dispute and you have someone filing here. When I go to the numbers numerically, there will definitely not be a case under Section 243 because we don't have a minority in terms of the numbers. But when we look at the facts, okay, of the case, the facts disclose a case of frustration, a member who is frustrated. So again, in such a context, we start by sitting you down, okay? As a mediator, URSB facilitates a discussion. If we reach a settlement, we file a settlement agreement. If you do not, sometimes we refer some of these cases because of the numbers that we have here, we refer some of these cases to professional mediation firms, okay? Or we ask them to go and first talk about it, which is a negotiation, and then report back. Sometimes there are cases where I will give a longer adjournment, and now I understand why we have some of these in court, because I really see no issue. This is an issue that I expect parties to talk about. So sometimes we give a longer adjournment, anticipating that let me give time, like a cooling down period, for these parties to first think about it, okay, before they proceed. Because sometimes you will look at the kind of decision you're going to make in terms of the law, and you see that really it's not going to help them in the business sense. So in summary, what is the best shareholding to take on? Do not forge shares. If we have a practice here where you'll just put someone and give them 50 shares just because you want to register your company, and we have what we call single member companies now. So you don't need to forge. If you are the one running your business 100%, why are you putting someone who has not contributed capital? Because these things are legal. When you put someone 50 shares as a shareholder, it means they have contributed 50% shareholding to that business, okay? It could be direct capital in terms of money. It could be indirect in terms of the skill that they are bringing on board or that kind of thing. So don't put someone on your subscription page if they have not actually contributed capital to that business. If you are the one footing your business, running it, equity is a form of raising finance. So you would rather start 100% owning your shares, okay? Don't concoct shares in your business. We have a single member company. Start as a sole owner. Then if you need to raise capital, let Lucy come and purchase 2 shares in your business, and then you can transfer 2 shares to her and we'll do the conversion, okay? If Daniel wants to come and participate in your business as a partner, you need capital, that's equity financing. It's a mode of raising finance. Instead of going to the bank to borrow 50 million, if I can give you 50 million and in exchange, you give me some shares, that would mean I have become a business partner and I am entitled to some sort of dividends. Don't concoct shares. So this question seems to me, Lucy, as if this person, because the way that it is being asked is like, why is this format of 60-50, 50-50 raising issues in terms of disputes? These are people that either are cutting and pasting. You get memorandums from somewhere, articles, then you paste and register your company and then go, because for you, the end goal is that you need to get the contract, okay? You need to get that deal. So they have asked, one of the requirements is that you must have a registered company. And then you come to me, if I am a fraudulent agent, I say, okay, I will not even charge you a lot of legal fees to register for this company, but give me 50 shares because I know you have a juicy contract. You have a contract of how many dollars, something, okay? So I end up putting myself as a shareholder in your business and I convince you that it's anyway not relevant. And you end up getting issues with me once you are eventually paid and I tell you I'm entitled to 50%, okay? So don't concoct, give people shares because they have earned it, okay? Don't just put someone in your memats. Then if it's a family, there are people that use shareholding as a succession measure, okay? Instead of writing a will, I'll just incorporate a company and give my children shares in the company and my wife, and it works because we have seen people avoiding succession battles in that way, where a family comes up and says, you see, this is the succession. If someone dies intestate, this one is entitled 20%. A child who you also don't know but comes after someone has died is entitled to 1%. And so you avoid it when you have a company, because then you know a famous case which I will not mention here, but where a famous lady was able to avoid the unnecessary succession battle that the gentleman's family had really put up, because she had 50 shares in the gentleman's company. So literally it saved her a lot of trouble because it meant that she was already entitled in terms of the business, and then the 50 shares, of course, were given to the child, and that's how they were able to avoid the extended family. So it can work as a succession measure, but please, please, please don't just put Daniel in your company because you just want to quickly register a company. It has an effect. Thank you, Lucy.
Thank you so much, Daniel. One more question for you regards beneficial ownership. They'd like to know whether you can include someone who is not a shareholder in the beneficial ownership form. And the specific scenario here is where the shareholder has children, and they want them to be reflected as beneficial owners. Can that be done without having them as shareholders in the company?
Yes. So, Lucy, a beneficial owner is anyone who indirectly owns a stake in your business. Now, people have misinterpreted this beneficial ownership form for a very long time now. And simply put, a beneficial owner is a person who might not be included in your subscription page as a member, but indirectly benefits or controls, influences the decisions the company makes. I might not be a shareholder, but for example, whenever I need to make a decision, I literally have the last say. So I'm not a member on file, but I am an indirect beneficiary, or I influence how decisions are made in that company. So The question on whether children can be beneficial owners in the company is again a question that I find inspired by that kind of practice of let me just fill that document. Okay, so a child can be a beneficial owner, but are they an indirect beneficiary in your business or in that business? Okay. Would you rather have them as shareholders in terms of having them on the subscription page? Because what's the effect of being a beneficial owner vis-a-vis being a member? If your intention is to have the company as a succession vehicle, okay, that your children should not have to go through a legal battle, applying late for letters of administration and that kind of thing, you want them to directly own the business once anything, God forbid, happens to you, then why are you putting them on the beneficial ownership page? Okay, they should be subscribers in the business, because a beneficial owner, the best example I can give you is, and you see, once I appear as a beneficial owner on the subscription page, once I appear as a member on the subscription page, I am automatically entitled to be recognized as a beneficial owner. That's why most of these beneficial ownership forms have the subscribers as beneficial owners, especially if you're saying we don't have that person behind the curtains, we don't have that invisible person. Okay, so there we will not allow you to file a nil form. We'll tell you to file the subscribers as the ultimate owners of the business. So my view is that yes, someone who is not a shareholder can be included in a BO form. But if the issue is about your children, then I would be of the view that you include them as shareholders as opposed to simply including them as beneficial owners.
Thank you so much, Daniel. I believe that we have all benefited greatly from this discussion. I would just like to note that everything we have shared is really trying to summarize what should be an entire training. And you need to take off time to study alternative dispute resolution as it applies in multiple aspects of practice, of our lives. Disputes arise everywhere. So we all need to equip ourselves and keep learning and improving our knowledge and practical experience in this field. On that note, I would like to invite our speakers to give their parting shots, starting with Laston, since Daniel has just spoken, and then we'll end with Daniel.
Yes, thank you so much, Lucy. My parting shots in a few seconds. Thank you as the moderator. Thank you for great moderation time. Thank the audience. I see quite a number of people joined the call, some quite prominent practitioners also on call. Thank you so much for being on call. I want to thank the LP Dispute Settlement Hub as well as Uganda Registration Services Bureau, the entities where the respective speakers are affiliated. And to Daniel specifically for giving us a lot of free legal advice. Some of the advice you're being asked, you are right to note that maybe some of these people may be having matters before your office, things of structuring companies, wisdom on how to best determine who should be on your members, who should be on the register of members. That is very valuable legal advice. And I want to thank you for your generosity and not holding back in giving us some of those practical aspects. From myself, it has been an absolute pleasure. The training that you recommend, Lucy, is a very relevant training. So I'll be looking forward, and hopefully the participants are also looking forward to when those trainings are rolled out. Some of the things we take for granted, even with your excellent legal knowledge, you can have a mismatch of application if you don't know how practically you are supposed to go about these company advisories, the structuring of company ownerships, the structuring of company governance structures, governing documents, and it is in those trainings that we add more value to what we already know. Thank you so much, and I want to wish you a lovely evening. Thank you. That is all from my side.
Thank you, Laston. Over to you, Daniel.
Yes, with this discussion, I think my parting shot would be that the most efficient way to resolve a dispute is ensuring that you do not reach the courtroom. If there is a way you can avoid the courtroom, if there is a way you can avoid adversarial litigation, please, if there are lawyers on this call, because we'll still get paid for our services, okay? And our clients will appreciate us more if we avoid them that stress, because a courtroom is like betting. You don't know really whether you'll win the case. Okay, you can go to court. I'm sure the lawyers on the call will agree with me that there are cases we have taken to court and we are 100% sure our clients have a good case, but unfortunately, judges have disappointed us. Okay, so why would you put your client on such a weighing scale if they have an option where they are sure they will negotiate their decision? Okay, it might not be the best decision, but they will participate in making that decision. So my parting shot is that as lawyers, as legal practitioners, if we have clients on the call that own companies, members from URSB, members in all these different, in the legal fraternity, let us embrace ADR. It is the new normal. If we have not really, and the clients will soon discover this secret because it is now everywhere. So if we have not equipped ourselves in this ADR, you'll find that clients will end up running to people that can actually solve their problems. So my parting shot is that ADR is the new normal. Let us invest in it. Let us build capacity in it, and let's continue such conversations. Thank you so much.
Thank you so much, Daniel. On the subject of investing in ADR, the Dispute Settlement Hub has a 40-hour training on mediation from 3rd to 7th August. Please reach out. They're still open for registration and you can start there. Otherwise, thank you for your time. Thank you for your participation. Thank you to our speakers and facilitators, Daniel and Laston. Until next time, it's been good.